joining us. We're going to go over the New York retainer for sellers. We're going to tell you, thank you for retaining our firm. You may have been referred to myself or my partner, Jessica Villaplana. The whole firm is going to work on your behalf, and that's a benefit to you. If one attorney's out, one attorney's on vacation, at least you have another attorney that's going to make sure they can work on your matters. We're only going to be retained for what we agreed to. It's typically just transactional real estate, buying or selling of a home. In this case, selling your home. Be careful for what we agreed to in your contract. The contracts are very specific. If you have this family heirloom that you do not want to provide to the purchaser, if it's not in the contract and you're excluding it, that may be going to that purchaser. It doesn't necessarily matter what was on the multiple listing service or what you told your agent. So please make sure the specifics of your deal match the offer you accepted. Make sure the price is right, the amount you're getting when this is all over is correct, what property you're leaving to your client, or what you're excluding for that matter. Make sure the dates work for you as well. Sometimes you may need what's called a post-possession, and we'll go over that as well. And that's typically when a seller is going to stay in the house for a set period of time. There's going to be money typically held back in escrow to ensure there's no damage when you move out. And there's typically a per day penalty if you stay beyond that date. So try to get all those terms agreed to up front. If you have tenants, and I know tenants, you can just tell why I'm saying this to you. I know tenants sometimes may be the greatest people you lived with for the last 10 years. It's a different story when you're telling them that they have to move out. There are new laws in New York when it comes to eviction or vacating a tenant. We can go on that on a case-specific basis, but just know that they require formal notice, and if you don't give it, you may be in default of your contract. So work with us. Maybe we can put some provisions in the contract that state you're going to use best efforts and define what those best efforts are, so that if the tenant does not move out, you're not being sued because you didn't provide a vacant home. We charge a flat fee for our clients. We take $350 at contract signing. So what does that mean? We're not going to charge you until you actually sign a contract. Typically, if that contract dies, we represent you again and just roll over that $350 fee. The balance is only due at closing unless there's a default. And default by you is more, I don't want to sell my home anymore. I can't find that other home I was looking for. Stephen, Jessica, just get me out of this contract. In that case, you would owe us the full amount for the amount of back and forth we're going to have to do and the work we provided. All my clients, I forgot to mention, do get a free tax preparation. You may really need that when it comes down to if you're subject to capital gains or not, especially with investment properties. We'll talk about that more in other videos and in person, obviously. But you have that benefit of free tax preparation. The only other additional fees are if you want to close with a power of attorney, or if there's some post-closing involvement, meaning post-possession like we spoke about earlier, or maybe some repairs that are going to go on after closing. And lastly, if there's a situation in which you're hiring us on a separate matter to help you clear title, and we agreed to do so. The responsibility to clear title is the seller. It is not the attorney. We let you know what has to be fixed. We can help you point you in the right direction of what to get done. But if you're hiring us to hunt down a 20-year-old ancient mortgage, or old mortgage, I should say, and get you satisfaction for something that someone else was responsible to do, but they didn't, that's on a case-to-case basis. We'll talk about if there's any fee charged or whatsoever. Lastly, just to sum up some things that have nothing to do with your agreement with us, but just some things as a seller I want you to be aware of. Just going back to evictions, we spoke about it. Start them right away if you have to start them. Don't necessarily trust the tenants no matter how good a relationship you are. Blame me, I'm the mean lawyer. Say, oh, my lawyer or the purchaser's lawyer required us to give you a formal notice. I'll be happy to let your tenants know that we required it, not you. We're the mean people. We'll let you know if there's any title issues. Please work on them as soon as possible. You only have a reasonable amount of time to fix title issues. If you have a loan modification in the past, there may be a silent mortgage. Please let us know if you have a loan modification ever, because this may really be the decision of whether you want to proceed or not. Please provide us with a loan payoff letter so we can kind of determine what you're going to walk away with. Closing dates in the contract are typically an on or about date. If you have a closing date of on or about 60 days, that means 60 to 90 days. That means you can close within 30 or you can close within 90. Sometimes you can use that to your advantage. Sometimes the other side can use that to their advantage. And lastly, if there is a legal dispute, even if you're in the right, only a judge can enforce a contract. We can argue on your behalf, we can send nastygrams, we can send letters, but if the other side is not willing to agree, then the only result will be court. Thank you. Hope you found this helpful. Give me a call if you have any questions. If you're enjoying the videos that you've watched today, they're not meant to be a substitution for speaking with your legal professional, but just an educational tool. Thank you.